Hello, my name is Jessica Williams, and I'm going to be giving you a presentation on the history of special education. On the slides that are on the history of special education that I thought were some very important acts. The first one is the Civil Rights Act of 1866. This act basically declares that all men, not women or all people, but all men of the U.S. were given the same principles as white men. And it was illegal to discriminate against men based on color, race, or whether they were a slave or not. So that to me is really interesting. That's kind of to me the start of it all, of all the special education, because right there it's talking about not discriminating against individuals or in men. Back then women didn't have the rights yet, but it's just very, very interesting to me that in 1866 they, made a law where as long as you're a man, you can't be discriminated against. On May 18th, 1896, Plessy versus Ferguson came into play. And I don't like this law. I'm glad that Brown versus Board of Education, 58 years after this was put into play, overturned it. But what it talks about is segregating. It was legal to segregate individuals based on, their race, their color, their ethnicity, and they had to have separate facilities, separate drinking fountains, separate bathrooms. It's a terrible, terrible, terrible law. I found a quote from part of this research that I was doing, and it says, it was upheld in the state's social or racial segregation laws for public facilities under doctrine separate but equal. When you purposely segregate people, they're not treated equally anymore. It talks. I watched a video the other day for one of my other classes that talked about Miss Elliott, segregated her class by brown eyes and blue eyes, and how that segregation made them feel when blue eyes were inferior to brown eyes, or brown eyes were inferior to blue eyes. It didn't matter which way it went. It just was how the kids felt so much different and how they didn't like being treated like that. So this Plessy versus Ferguson law, I feel is very very bad for our society. I'm like I said before, I'm really glad that Brown versus Board of Education came into play, because and overturned this law. So in October 6th of 1954, Brown versus the Board of Education was signed into law. It reversed Plessy versus Ferguson. So this law is, it consolidated all the segregation of public schools in the United States. This is when the desegregation was going on, the fights, there's still a ton of discrimination, but everyone was welcome into the public school system. And I feel as though, that's a huge step for us, because as hopeful special ed teachers, we need to understand, you know, we need to be able to understand exactly where the segregation comes from. In 1971, Mills versus the Board of Education of the District of Columbia. This is one of two important federal trial court rulings that helped to lay freedom foundations that eventually led to passage of Section 504. This is known this also is important because it talks about how this law comes into play, because it's all students are now treated, they all have equal rights. So they're supposed to all be treated equally, which is huge because, as we know, we have some exceptional students that need this extra care that we are here to provide them, and they need to have the same rights that every other student has. I found that the public law number 94/142, it was the Board of District Columbia denied access to education for students who were with special needs. That's appalling. We need to be able to include everyone, and I know in 1971 it was a completely different time, but this law is a good law. In May 5th, 1972, the law was passed. It was called Pennsylvania Association for Retarded Citizens versus Pennsylvania and Mills versus the District Board of Education. What this talks about is basically the courts decided that children with mental disabilities would be given free and appropriate public education. So, no, we weren't there to discriminate against them. They were welcomed with public schools. I do have a website on my slide that you can go to and learn a little bit more about it. In September 26, 1973, Section 504 Rehabilitation Act of 1973 was upheld or was signed into law. It was signed by President Nixon, prohibiting discrimination in the workplace or schools. It also talks about how plans need to be mandated for individuals for eligible disabled students. So this could be something from a kid has a concussion and he needs his work assignments modified. It could be there's a behavior student that needs a modification to their schoolwork plan. That's basically what 504 is. Modifying or individualizing their schoolwork, their day, their whatever, to help them get through the day. November 29th, 1975, the Public Law 94-124, or 142, excuse me. This is the education for all handicapped children. This law secured the basic ideas, responsibilities, rights, to ensure equal access to public education for all children who are disabled. This is, very important for us because, we wouldn't have special education if we didn't have some of this, some of these laws today. It does talk about it says in my slide that the key element being that prior written notice be provided to the parent regarding purposes or refuses changes to identification, evaluation, or education placement of a child, or FAPE. What FAPE is, I believe that's important to know so you can understand the slide. FAPE is free, appropriate public education rights of children with disabilities in the United States that is guaranteed by the Rehab Act of 73 and IDEA. No, this is important, like I said, because if we didn't have this law, we wouldn't have most of our children that we have today. And the 1982, the Rowley decision. This is an act that it's an interpretation of the Education for All Handicapped Children. It's now known as the Individuals with Disabilities Education Act, the IDEA. So what they do is there's a two-part test that is implemented now when working through specific case issues to help better determine the child's needs. On July 26, 1980, the American with Disabilities Act, ADA, was put into law. You can't be discriminated by your employer. Services provided by state and local governments in place of public accommodations, transportation, or telecommunications. So basically, you can't discriminate against someone that has disabilities. You can't discriminate on the basis of sex, race, national origin, or religion either. So, you can't discriminate because they're blind or, anything. You can't discriminate. Then the last slide that I have is in 2001 they put in No Child Left Behind Act. I personally have a problem with this law. It's the act itself is to level the playing field, or so they say in the education field. But I feel like it didn't level the playing field. It brought kids down, and it didn't help them educational wise. Like, I feel as a teacher, as a soon-to-be teacher, hopefully, that No Child Left Behind is a silly act, because those kids that need to be pushed were held back because we couldn't push them onto a new subject or onto something difficult because we had to wait for the rest of the class. And there's learners that are strong learners, fast